Good afternoon and welcome to this special setting of the Court of Appeals. We have one case on the docket, SEBCC Building LLC versus Morgan Stanley Smith Barney Financing LLC. I see counsel are set up and ready to proceed. Does either of you have any questions?
Good afternoon, Your Honor. I do have a question. Julie Walker on behalf of Appley. Because we have a cross appeal in the case, I did not know if the court in any way provided for the Appley to adjourn time on the cross appeal or whether it was just 15-15 for each side.
We do not. It's 15 less whatever the appellant reserves for rebuttal. Appley and cross appellant goes in the middle up to 15, and then any time saved by the appellant can be used, but it's not a two-cycle back and forth.
Okay, thank you.
Otherwise, a brief reminder to our spectators, if any of you has a cell phone or similar device, would you please turn it off so the lawyers are not interrupted. And this is a reschedule of a storm day problem, so we appreciate everybody's cooperation in getting together, and we will hear argument in the case today.
Thank you, Your Honors. May it please the court, counsel, my name is Alan Sweetbaum, and I represent the appellant Morgan Stanley Smith Barney Financing. We had quite a number of topics in our brief. I'm going to try to address some, not all of them, in the 15 minutes I have allotted to me, but I wanted to obviously start with the issue that relates to the question that was asked in this court's March 6, 2019 order, which related to the early bird program. To answer that question directly, the record does show, in fact, increased revenues that were generated by the early bird program. It specifically identifies the amount of increase by month. It's a little hard to find, so what I prepared was a demonstrative exhibit on that poster board. I'll get to that in just one minute. But the information that I think you're looking for, at least that I hope I understood that you're looking for, is found in Exhibit XX, which is the spreadsheet that was prepared and testified to by the defendant's representative, Chris Kendrick. She actually prepared an analysis of some parking data that were provided to us by the plaintiff, and that's what Exhibit XX is intended to represent. The testimony at trial, which is also obviously in the record, is that the early bird program started in February of 2013, and it went on for a period of 9 to 10 months. That could be found in the record by the testimony of Brendan Bengal at page 369, starting at line 18, and page 459, starting at line 5. What Exhibit XX shows is the revenue that was generating during that period of time, during that 9 to 10 month period. And again, this is right off of Exhibit. I'm not supposed to leave the podium, am I? I apologize. So what Exhibit XX shows is starting in that first time.
So I could see the exhibit.
Well, do you want to just come up and it's...
If that's okay.
Yeah,
I apologize.
it's pretty self-explanatory.
Yeah.
I mean, you may quarrel with the content, but I think...
I didn't see it before today. So
Okay.
Counsel, I have a question. Is
Yes.
that the increased revenue from early bird, or is that the total for the month?
Those are the totals regarding what's called transient parking, which is the non-reserved parking spaces. Again, starting in February 2013, to $7,552. You can see it then slowly increasing through March and April. By May, $11,842. Going up to $15,000 and change in June, July, August. It drops down a little bit in September and October. It hits a high of $16,250.
How do we know that's all attributable to the early bird program?
That was what the testimony was at trial. That is what that exhibit was accepted by the trial judge as the amount of revenues. Again, that was a summary or an analysis prepared by the parking data that was provided to us by the plaintiff. So although it was a somewhat complicated, they had monthly parking reports that were somewhat complicated. We went through it. We had the summary prepared. We had the summary testified to by Ms. Kendrick, and it was accepted by the trial court. So I think that's the only testimony. I don't think there's any dispute, Your Honor, about whether or not that was the exact amount of revenues. And I think what it shows, what this demonstrative shows, and also what Exhibit XX showed, is that it increased directly as a result of the early bird program. But to clarify, it is one of our arguments, but it's not our only argument that essentially that increased revenue should be applied to offset the damages alleged by plaintiff. Our argument is a broader argument, and I just want to talk about that briefly. So the testimony at trial was that the landlord, again by Mr. Bengal, was that the landlord instituted that program to increase the revenues, and after that period of time, 9 to 10 months, it was so successful that the garage was actually filled beyond capacity. What Mr. Bengal testified at page 454, starting at line 16 of the record, is that at that point there was at least one parker who had reserved spots who couldn't find a space. He reported it, and when that became apparent to the plaintiff, they terminated the program, the early bird program. So the institution and termination of that program shows, it is our position that it shows that the plaintiff either did or could have completely mitigated any damages it was complaining about, it was alleging. Mitigation, of course, is one of the critical issues that we raised throughout the trial. It was our main affirmative defense. It was argued extensively during the trial. And of course, I think it's undisputed that the law is that a landlord under a lease, actually in fact any contracting party, has the obligation to mitigate its damages. The issue, by the way, was not addressed in the summary judgment order, which is one of the arguments that the plaintiff was making. It was not waived in the lease. That was specifically, again, found by the trial court judge. And I think that the evidence does establish that the landlord either could have completely mitigated its damages or did completely mitigate its damages if it continued with the early bird program as opposed to terminating it when it became full beyond capacity. So it's based upon that argument, failure to mitigate, that we think that the plaintiff is entirely precluded from recovering any damages.
Is the garage, are all the spaces in the garage allocated to monthly permit holders? Or is there some unallocated space that's available to daily parkers?
There's absolutely, there are what they call the unallocated spaces. There are spaces that are specifically for monthly. There are spaces that are specifically, actually, this garage also serves a lot of the retail around Cherry Creek, and there are spaces that are specifically reserved for some of the retailers around the Cherry Creek area. And then there's also time-limited spaces. There's obviously handicap spaces, and those are all marked, and that's what Exhibit XX analyzed. It analyzed how many total spaces that there were, and what the testimony of the defendant, Morgan Stanley, Ms. Kendrick, was, based upon this analysis, was that there were a total of 217 unreserved spaces, and that was accepted by the trial court specifically in the order. So that revenue is what is generated from those 217 spaces. Did I answer your question? I tried.
Well, I don't want to consume your
Okay,
argument,
thank
your
you.
time needlessly with
Okay.
this level of detail.
The second issue deals with the expert testimony of Brendan Bangle, and this may seem like a somewhat minor issue. It flows directly from and is related to this issue of mitigated, our argument that there was a failure to mitigate damages. So as I just said, Exhibit XX shows, and the court agreed, that there were 217 unreserved parking spaces that were available for permit, that were available, unreserved parking spaces. We also showed that plaintiff had sold more permits for unreserved parking than were available. That's again actually in the course order, page 4 of the course order. So if the analysis stops there, you just say there's this many spaces, they sold more than that. If it stops there, I think it would be conclusive that at that point the landlord had fully mitigated its damages. But what happened, one of the reasons why we are where we are today is that the court then allowed the testimony of Mr. Bengal about overselling the garage. Specifically, the judge allowed Mr. Bengal to testify that it is standard industry practice to sell more spaces than there are available, and as to industry averages about what percentage of overselling they should be. I don't doubt that this is a practice that parking users use. We all know airlines use it until someone's dragged off the plane and sues them. But that's a reference, I think, to United Airlines. But in any event, the problem is when Mr. Bengal was allowed to testify about that, he wasn't designated as an expert. He was allowed to offer what we believe is clearly expert testimony. It requires the specialized knowledge, experience, and training. And by the way, there's an argument about whether this issue was preserved. We objected to it. We actually filed a motion in limine on this issue. And the testimony of Mr. Bengal was admitted over our objection. Actually, if you read the court's order, they actually refer to this Exhibit XX and this whole issue as compelling evidence. The court held, sort of ironically, that he was going to allow it, and the issue about whether or not our objection was valid would go to the weight and not to the admissibility of the evidence. In fact, it is our position that this is the exact type of expert testimony which needs to be disclosed, which we are entitled to see ahead of time, which we're entitled to rebut if we think it was necessary. We didn't get any of that opportunity to do any of that because he wasn't properly disclosed as an expert, and the court allowed him to testify as to expert testimony. So the last issue I wanted to address, I say I only have a little over 4 minutes to go, is the issue.
Counsel, why don't you take another 3 minutes and the bailiff can add it to the clock, and I'll give your adversary the same, because I feel that I kind of diverted your argument into the weeds here, so.
I very much appreciate that, Your Honor. Thank you. I know that's not a normal thing, so I appreciate that. So let me turn to the issue of latches. And I don't want to be presumptuous because I'm going to refer to a case that Your Honor authored, that Judge Webb authored, in Re the Marriage of Khan. And I don't want to interpret something differently than maybe Judge Webb intended, but I'm going to give it my best shot. So we believe that the issue of, or the doctrine of latches directly applies to the facts in this case. It was decided on summary judgment, and as a result, we believe it can be reviewed by this court on a de novo basis. Just a couple of real quick facts. I know that you don't like counsel to go over the facts, but this claim goes back 13 years. During that time, it is undisputed that there was no notice, there was no demand, there was no invoice. What happened was on January 17, 2014, 13 years after the lease was signed, which is the subject of this lawsuit, Morgan Stanley, the defendant in this case, received an invoice for $322,275, which was exclusive of interest. And by the way, the interest that was calculated by the plaintiff when this lawsuit was filed was at the rate of 18%. For that period of time, 13 years, you can imagine what that added up to. The total claim was close to 7 figures. No notice of any of this beforehand. So the element of latches, I think, which are established by the Marriage of Khan case, 2017, Court of Appeals 94, there has to be full knowledge of the facts by the plaintiff. The plaintiffs it has to be shown the plaintiff's unreasonably delayed in asserting the claim, and there has to be a showing of reliance and prejudice by the defendant. By the way, the reason why I just raised the 18% is I think that's the prejudice right there, or at least certainly an argument. The Marriage of Khan case, we believe, although it was a a case having to do with enforcement of a maintenance agreement in a dissolution action. We believe the facts are remarkably similar. There was a failure to enforce the maintenance obligations and agreement for 26 years, and this court held, Your Honor, in the opinion you authored, that the doctrine of latches applied in this case. What Judge Mullins did in his summary judgment order
Counsel, how do the elements apply here? The three elements you just,
So I think there is full knowledge by, not by the plaintiff,
because of what?
because they signed the lease. They were aware that there was a provision in the lease that required that the defendant, the tenant, pay for parking. There obviously was an unreasonable delay in asserting the claim, and we believe there was reliance and prejudice on behalf of Morgan Stanley.
Because of the prejudgment interest.
Well, that's certainly one fact, absolutely, yes. But certainly, we could have done things in the interim if we were aware that they were doing it. We could have sold the parking spaces, maybe. We could have tried to negotiate something different. But just the interest rate alone at 18%, which is, what, 10 times what a normal interest rate is, I think shows that there's prejudice. What Judge Mullins did in his summary judgment order was he held that the defense didn't apply because the parking agreement provided notice to the tenant, to the defendant. I think that's the wrong standard. That's really not, if that were the standard, then in marriage of con, there wouldn't have been a laches defense, because certainly both parties knew about the maintenance agreement. By the way, we believe that all the elements exist. We think based upon the record, you could hold that there is, in fact, a laches defense, but at a minimum, it shouldn't have been decided on summary judgment. If there are questions of fact, it needs to be remanded back to the trial court for determination regarding that defense. So I have 2 minutes and 40 seconds, even with the 3 minutes you gave me extra, so I'll reserve that for rebuttal. Thank you.
And the clock shows the bailiff has given you the same amount of extra time.
Thank you. Good afternoon. May it please the court. Certainly from a day of a bomb cyclone, today is a much better spring day to be here before the court, so we appreciate the opportunity. This case really started out and really should be viewed as a simple breach of contract case. Judge Buchanan, in his decision on the attorney's fees in the August 18th, 2017 transcript, on page 13, it was an oral ruling on the attorney's fees, found exactly that. After a 4-day bench trial and substituting in the case after Judge Mullins retired, Judge Buchanan found this was a simple breach of contract case. Liability was ripe for determination on summary judgment. It wasn't a terribly complex damages case that you might even regard it as a math problem. The only complex issue in this case arose from the defendant's overselling defense, which is the Exhibit XX, which I'll address, that the defendants vigorously pursued, that my client ended up spending $200,000 in attorney's fees to defend, and that ultimately was unsuccessful at trial. It's important to understand that framework as you consider the issues on the appeal as well as the issue of attorney's fees that we have appealed. Plaintiff started out this case with conversations and consent from the initial counsel for Morgan Stanley. This is a straight-up commercial landlord-tenant breach of contract. We should get to liability on summary judgment as quickly as possible and spend as little as we need to in order to resolve the case. Morgan Stanley's initial counsel agreed, and as we cited in our brief, we agreed for the almost unheard of case management order that would expedite and shorten the time period for discovery. We agreed each side would have one 30B6 witness to get discovery on damages, and there would be no need for experts. This is a math problem. We filed our summary judgment motion as expeditiously as we could after spending somewhere around $50,000 in fees. Judge Mullins granted liability on summary judgment, and from that point through the 4-day trial, as I said, we spent $200,000 defending against the aggressive litigation strategy that was put forth by Morgan Stanley after they decided to change counsel. The fee decision in this case, which is the subject of our cross appeal, was prejudicial to my client, Your Honors, because the court ultimately, at the end of the day, and I'll go through some of the details, put a percentage application to the total fee petition that we requested based on a comparison between the total rent that was sued for and what was recovered after the finding applying the statute of limitations. We don't necessarily disagree with the judge's perspective that perhaps a proportional analysis is appropriate, except in this case, it should really only be applied to the $50,000 that led to the summary judgment, because that's the point in time where we lost our initial argument for the total amount of rent. From that point on, the bulk, 4 times the amount of attorney's fees, was spent defending against how the damages were going to be calculated. So to apply that proportional percentage to those fees was an abuse of discretion. I want to go to the court's question and my counsel's proposed response on the early bird. And before I address specifically his demonstrative and Ms. Kendrick's XX, I want to step back and discuss a little foundation for the court as to why this theory of early bird revenue would not present evidence of partial mitigation, regardless of whether Morgan Stanley's argument that the evidence is in the record is correct, which we will dispute.
Well, and you may call this a simple math problem, but I'm not sure I'm on top of it. Is the early bird, forgetting about exactly what the numbers are the revenues from the early bird program coterminous with the revenues from overselling, or are those apples and oranges?
I think they're apples and oranges in some respect, and I think I can explain what I mean by that.
Well, maybe part of my confusion is, did the operator of the parking garage oversell by granting more monthly spaces, or did it oversell by allowing more daily parkers into the garage, or both?
Potentially both, Your Honor, but the income is not tracked in that way. So ultimately, our answer to your question about whether the evidence is in the record of what revenue was earned by early bird, there is none. And what I brought a copy of one of the monthly financial statements. It's in the record, but to the extent the court wanted to look at one for purposes of oral argument, to demonstrate to you it's not in the record. I don't know where these numbers came from, because I happen to have the June 2013 monthly financial statement, and the line items for transient income do not equal $15,783. In fact, I can't even find that figure in the monthly statement, so I don't know where it came from.
Well, counsel said it came from Exhibit XX, which we can look at.
Yes. But what's in those monthly financial statements, Your Honor, there is one line item for each different bucket of revenue that's earned by the parking garage. So you have reserved parking spaces, which we're not talking about here.
Well, that's permits, right?
Well, there are 2 different types of permits. There's a reserved permit and an unreserved permit.
Oh, okay.
Reserved permit, 24/7, you have access to that space, so you pay a monthly fee for that space. Unreserved permit, you have access to the garage, you've got monthly access to the garage, but you don't have a designated space to park in, you just have the right to park in the garage. So you have those 2 categories. Then you have what's called transient income. We've probably all been in this parking garage. You may not know exactly which one it is. It's in Cherry Creek, right between First and Second, next to the A&B Bank building. Often used for retail shoppers at Cherry Creek who come in at 10, maybe they're there for an hour, maybe they're there for 5 minutes. Those are transient parkers. Anybody who pulls a ticket when you go into the parking garage. So there's one line item in the monthly statement for transient parking. That could be the shoppers at the mall. That could be the construction workers that are working in Cherry Creek. That could be an early bird participant who shows up at 6:30, pulls a ticket, gets the discount on the rate. Maybe that person stays all day. Maybe they stay some shorter period of time. There is no distinction in the financial records that are kept by the parking operators as to what dollar is an early bird dollar and what dollar is a non-early bird dollar.
They're just all daily transient.
It's all transient income. So the answer to the court's question is no, the evidence is not on record. I disagree with counsel's description that Exhibit XX breaks out this early bird revenue. In response to the court's question, I spent a fair amount of time searching the trial transcript to see whether there was any evidence on early bird revenue. I found none. I found Mr. Bengel's testimony about the early bird program, which I think the court is well aware of. No evidence that in any way would support dollar figures that you could attribute to early bird. But again, I want to take a step back and present to the court why this issue would not prove what Morgan Stanley wants to show as partial mitigation. The parking garage is oversold. It's a term that you see frequently, but not sold out. Mr. Bengel's testimony about the utilization study that was done in 2012 gave a recommendation to the client. We've determined, again, based on his math calculation, that even Morgan Stanley admits would not be expert testimony. The only piece of it that they claim is expert testimony is this 70% industry average that they don't want you to be able to consider. But his math was, they went out there every day, every hour, counted how many cars were in the garage, how many parking spaces were free, did a math calculation, and determined that the garage was presently being occupied at roughly 48, 49%. So the advice to the client was, you can sell more permits. You could institute an early bird program. You could make more revenue from your parking garage, which they did. 9 months later, there's one anecdotal evidence of an occasion where one of the permit holders, so a tenant who had a unreserved permit, could not park. That was a breach for the landlord to its tenant. They're obligated to give parking spaces to those tenants that pay for those permits. So they ceased the early bird program because they could not continue to put themselves in a position where they had potential breaches of every one of those permitted parkers. So they stopped the early bird program. So there has to always be this cushion between how much revenue can they get from transient parking, how much revenue can they get from the permits that they're obligated to provide.
Here's what I'm not understanding. And I'll just take the number of 25 as the permits that are in dispute here. I think it's 22 or something.
Something like that.
Okay. If Morgan Stanley had been aware of those permits and had given them out to its employees, or I suppose it could even sold them to third parties, then there would be that much more occupancy of the garage. So isn't what you describe as the cushion larger by virtue of the fact that there are 25 approximately permits here that exist only on paper and nobody's ever using those permits to fill up a space in the garage?
Intuitively, Your Honor, you'd think that it would be a finite black and white number, but the problem is it's not, because you can imagine, I'm a partner in a law firm, I have a permanent parking space, I'm entitled to have that parking space every day, but I'm not in the office every day.
Well, I agree. I mean, whatever utilization discount the statistics say would probably apply to the permit holders as well, but the point is the base number is going to be different. If you've got 25 spaces there that are never used, then the utilization, never used because nobody knew Morgan Stanley didn't know it owned them. It seems to me that the base number from which the utilization can be calculated is artificially low.
The problem is it's not a determinable number. And I think that's the reason why Judge Buchanan rejected that theory at trial and opted for the mitigation theory relying on the fees that were paid by the employees who actually paid for them out of their pocket even though Morgan Stanley was supposed to be providing permits to them. That was a determinable amount of money that he could then calculate and credit as mitigation towards parking fees that SEBCC would have otherwise obtained. The transient nature of the garage and who's there, how many permits they could sell, they can always oversell. They have to be able to accommodate another tenant who may come in or a current tenant who wants to increase the number of permits. There isn't a finite number of permits or revenue that they could define or expect to achieve under any circumstance. And it goes back to this cushion. They always have to be able to be in flux to be able to accommodate more transient parkers during the Christmas season, or more permit parkers who are going to be in the office when they otherwise may not be. And again, while you get to that one day where it was sold out, not oversold, but sold out, that they had to cease this early bird program in order to not be in breach of their tenant obligations. The duty to mitigate has a standard that the party has to be held to act reasonably. And so it would be unreasonable to expect SEBCC to have to institute an early bird program or some other transient income program that could potentially put them up against this breach with their tenants under which they have a commercial obligation.
Counsel, can I switch gears?
Please.
The latches issue is
Yes.
of concern to me. The trial court awarded contract damages of $140,000 and prejudgment interest of $147,000. Isn't it the case that unreasonable delay is a question of fact, typically, and don't we have a fact question here in this case?
I would argue that the laches defense does not apply, Your Honor, for two reasons.
Okay.
One is that I think Judge Mullins relied on the Keller-Cattle decision, which actually refers to City of Thornton, which is the more applicable set of facts to this circumstance. The holding under City of Thornton is that if a party does not have an obligation to act to secure their rights, then the laches defense does not apply. And so in this circumstance, because the plaintiff did not have a duty to go collect rent from its tenant, the laches defense does not apply here. And that's why he was focused on Morgan Stanley's knowledge, because Morgan Stanley is the one that had the knowledge that they needed to pay.
Well, how would Morgan Stanley,
No, please go ahead.
how would Morgan Stanley know that Citicorp or the predecessor tenant hadn't been paying?
I'm sorry, how would they know that what?
The predecessor hadn't been paying.
That evidence is all in the record, Your Honor. We briefed it extensively on summary judgment because we made an equitable tolling argument against the statute of limitations defense. And we had testimony from representatives of Morgan Stanley and documentation that went back to 2001 that showed the predecessor entity records knew each lease agreement, how many permits they were required to take, and that they hadn't been paying on those permits. So that evidence was well within their knowledge, and each subsequent tenant from that point. And there were employees who were employed across the board in a similar role for that same responsibility. So there's no question in the record that Morgan Stanley or its predecessors shared that knowledge and knew that they had not been paying.
But why didn't SCBCC also have that same knowledge when they got reports every month from the parking person, whether it was Republic Parking or Standard Parking, that there were spaces that were available that the tenant wasn't paying for?
I'm glad you asked that question. The evidence that's cited by Morgan Stanley on the knowledge of SCBCC shows they knew how many permits were required under the lease, and they knew how many permits were assigned to employees, because they all have to have that electronic assignment. There's nothing in that documentation that showed that the permits were not being paid for. So they had to take 23 permits. They had to pay for 23 permits. But if they'd only given out 15 permits to their employees, that's the only evidence that was in those charts, was how many employees were assigned to permits. Not anything about were they paid for, or if not, that they're paid for. So there's no evidence of knowledge that SCBCC knew. To Your Honor's question about reliance and prejudice, my co-counsel, with all due respect, says that there's evidence in the record of reliance that they could have done something else. There's no evidence of what else they would do. There's no prejudicial reliance in this case. They knew they weren't paying. If anything, their reliance garnered them money in their pocket that they didn't have to pay, and they got the benefit of the statute of limitations, so they got 7 years that they didn't have to pay. This argument about the 18% contractual interest being prejudicial, it's in the contract. Morgan Stanley made the same argument to the trial court, that the trial court should equitably reduce their interest obligation because of the length of time this case took. But Judge Buchanan also found it is a contractual obligation. It was a contract that was negotiated between two sophisticated entities. There's no prejudice there from that interest.
Thank you.
I see my time is up.
I'm going to try to bounce around here as fast as I can. Regarding latches, the only holding in this court's summary judgment order, it was a different trial judge, Judge Mullins, as opposed to Judge Buchanan, is found on page 7 of his summary judgment order. The parking agreement provided notice to defendant of its obligation to take and pay for parking permits. Defendant's obligations were not dependent on action of plaintiff, thus the doctrine of latches is unavailable as a defense. That's the only holding. We think that's wrong. We think that could be reviewed de novo. When Ms. Walker talks about there isn't evidence in the record about reliance and prejudice, well, that's because it was decided on summary judgment. By the way, I think there is a record. There is some evidence in the record, and you could reverse and hold that there is latches, but I think probably we're more conservative, more safe in asking that it be remanded so that this can be tried. I also wanted to address the issue of Exhibit XX when Ms. Walker stated that she couldn't find it. I think she mentioned October 2013. If you actually turn to that page, October 2013, that number, $16,250 is in there. All the numbers are right from Exhibit XX. By the way, this issue of one day it was sold out, this is sort of in flux. This is something that kind of moves around. The reason why that's important, that one day that there was testimony that this monthly permit holder couldn't find a space, that's what happened that caused Mr. Bengal to terminate the early bird program. If it would have stayed, any damages they could possibly claim would have been fully mitigated. Real quickly, in my 45 seconds left, attorney's fees, I just want to address that just by saying this real quickly. It is the abuse of discretion standard. I don't think anyone's disputing that. The case law clearly gives the trial court judge here, Judge Buchanan, the discretion to determine the amount of attorney's fees, and based upon his findings and his conclusion, there is no basis for finding that he abused his discretion in any way. Ms. Walker started out by saying this is a simple breach of contract case. First of all, we don't believe it is. But in any case, if it is a simple breach of contract case, the 3-year statute of limitations applies, not the 6-year statute of limitations applies.
What about the statute that talks about a 6-year statute of limitations?
It applies to arrears of a debt. It applies to arrears of rent. But this was tried as a breach of contract case. That was the only claim that was asserted, a breach of contract claim.
So this is
and
not
if
an arrears of rent case?
I think that's certainly what Judge Mullins held. That's why I didn't argue that initially. I'm not arguing it's my strongest argument. I'm not saying it's my strongest argument. But if it's a breach of contract case, as Ms. Walker says, it's a 3-year statute. Thank you.
We appreciate the arguments of both counsel. The case stands submitted. We will issue a written opinion in due course. Counsel are excused. That completes our docket, and the bailiff may announce a recess.
All rise. The court will be in recess, subject to call.